Hi, this is David Pivnick at McGuireWoods, and I'm joined today by my partner, Michael Podberesky, and wanted to take the time initially to thank everybody for joining us today for the webinar. We're going to try and be helpful and informational and make this a useful expenditure of everyone's lunch hour. We'll be talking about today about what to do when the government comes knocking, which both of us have focused our practices largely in the healthcare space, and that's becoming an unfortunately increasingly common occurrence. And we want to go over some things that you might expect to see, as well as some tips and best practices for responding in the event that you ever are subject to a government investigation and the government ever does show up with service. So we'll start by just brief introductions of myself, and I'll allow Michael to introduce himself. As I said earlier, my name is David Pivnick. I'm a partner in the Chicago office at McGuireWoods. Have been at the firm for approaching 11 years, actually, in about a week. Actually, in a week today, it will be 11 years. And my practice is focused entirely on healthcare litigation throughout that time, and primarily provider-side focused practice, and largely spending time handle a lot of commercial disputes, but largely spending time dealing with government investigations, both in terms of conducting and responding to investigations, as well as defending against government fraud cases, whether it's false claims cases or otherwise. So certainly I've dealt with a lot of the issues that we'll be talking about today, and look forward to speaking with all of you about it. And I'll allow Michael to introduce himself.
Thank you, David. Good afternoon, everyone. My name is Michael Podbareski. I just joined McGuireWoods from the DOJ Civil Fraud Section, where I prosecuted fraud cases under the guise of the False Claims Act. Probably handled roughly 50 False Claims Act matters in my 5.5 years there, primarily in the healthcare space in a wide range of sectors. Prior to going to DOJ, I spent 7 years at a large international law firm where I was a general commercial litigator. And prior to going to law school, I served in the Navy, so this is a bit of a second career for me. And again, echo David's words, welcome, and appreciate everyone joining in. Why don't we dive right in and talk about the investigators' overt tools, starting from top to bottom, sort of most intrusive to less intrusive. At the top end, you have a facility search. So this is law enforcement arrives at your facility with a search warrant in hand and begins to seize documents, computers, and other items that could be potential evidence. They could also have arrest warrants in hand so that they could seize individuals. Hopefully that won't be the case, obviously. Moving down the spectrum, you have subpoenas. Those can be issued by a grand jury, and a grand jury subpoena can be for testimony and or documents. From the Civil False Claims Act perspective, you have what are called civil investigative demands, often referred to as CIDs, and those are subpoenas for documents, information, what we call interrogatories, or testimony. And then the Inspector General offices, the IG agents, have the ability to send subpoenas, but those are for documents only. Another tool, overt tool investigators have is obviously just sort of cold calling and walking up to current and former employees and interviewing them. And then finally, agents and prosecutors can just pick up a phone or send an email and submit informal requests to subjects of investigations or third parties. So that is the spectrum.
And Michael, can you provide a little bit of your perspective, particularly having recently come from DOJ, as to when the department might choose to use each of those various tools? What are some of the factors or considerations that are underlying that decision-making process for the Department of Justice?
Sure. So, obviously a search warrant, a facility search is something done pursuant to a criminal investigation. The decision whether to handle something criminally, civilly, or both, a lot of it is going to depend on how egregious the conduct is, whether there was patient harm, if if a physician was just manufacturing thousands of invoices out of thin air, or worse, cracking open chests and performing heart surgeries that did not need to be done, weren't even close calls, that's probably going to be handled criminally, and a search warrant and grand jury subpoenas are likely tools to be used. If it's more in the realm of a Civil False Claims Act case, whether or not to use a civil investigative demand or an informal request they'll also look at how egregious the conduct is, but they'll also look at, one, is the subject of the investigation, is it a reputable company with reputable counsel? And they'll also look at, does the issue appear to be systemic or a one-off? If it's a reputable company that has a decent compliance function, is represented by reputable counsel, and it looks like there was a bad apple in one far-flung office, in that situation, the prosecutor may issue a informal request, which requires less work from the prosecutor. If it's a company no one's ever heard of, and it looks like the conduct that they're sketchy and they're not going to cooperate, then the prosecutor will most likely choose to go with formal process in the form of a IG subpoena or civil investigative demand.
Great, thank you. That's very helpful.
And I should also add, if the prosecutor chooses to go the informal route, hanging over the subject's head is the threat that if the subject of the investigation is not producing documents and information in a responsive, cooperative fashion, the prosecutor can always then serve formal process in the form of a subpoena and move to compel if necessary. So moving to the next slide, let's talk about practical tips for handling a search warrant execution. So first tip is be prepared in advance. Have a written plan protocol in place and train employees, particularly senior employees on site, clinical managers, site managers, for what to do if government agents show up at the door and literally knock on the door. And then in terms of what to do the day of the raid, first and foremost, you see bolded and underlined here, do not interfere with or attempt to obstruct the search. Don't get in an agent's way and say you're not allowed to go in there. That's not part of the search warrant, or the company doesn't own that. That's my own computer. That can get someone arrested for attempted obstruction of justice, and obviously we don't want that to happen to any employees. So what you want is to have a designated representative, most likely the senior employee at that particular site, who is assigned to interact with the senior agent. They should ask for a copy of the search warrant and to view the senior agent's credentials. Then they should promptly call counsel and have them come to the facility as soon as possible. And then, they should call counsel on their cell phone and literally hand the cell phone to the supervisory agent so that experienced counsel can take the lead in interacting with the agent until they can arrive. And if they can't arrive, they can do it virtually via phone. And what counsel will do is he or she will voice objections to searches outside the scope of the warrant. They can request an inventory of any seized items. They can take steps to protect privileged information, and they can determine whether it would be useful to provide assistance to the agents or whether it's best to remain silent, let the agents go about their business. So obviously it's best to let counsel do this because they have experience handling this situation, but also just practically speaking, agents are going to be a lot less likely to arrest an attorney than they are a clinical manager. It's a lot more paperwork for the agent and a lot more questions for them if they arrest an attorney.
And Michael, just before we move on and actually circling back to the prior slide, one of the questions that we got asked from one of our attendees today is, for each of the government's investigatory tools, is there any ability, or what is the ability of the subject or the respondent to refuse to cooperate with the government, and what are the implications or consequences for that potential refusal? Can you speak to that?
Sure. If obviously we have a Fifth Amendment right not to self-incriminate, so you don't have to answer questions. A gray area is what do you have to do in terms of producing documents. There's case law that you don't have to, by picking out and identifying documents that infringes on the right against self-incrimination. And in the criminal realm, there is no negative aspect to exercising that right? Like a jury cannot hold that against a defendant. However, in the civil realm, or if it's a parallel investigation, if you plead the Fifth, that won't be held against you for any criminal charges. But in the civil realm, if you refuse to answer a question or cooperate, that can be held against you, and a trier of fact can make negative inferences from that refusal to provide responses. So those are the implications of that decision.
And I'll also just add there, I think addressing the parameters of that question in the real world, when things actually come up, I think is a perfect example of why it's prudent to have sophisticated counsel who's dealt with this before involved, both because they can help liaise with the government and see if there's ways to limit or narrow the scope of what's being requested, and to potentially, in a cooperative way still minimize the inconvenience. And they could also walk through and make sure that the search warrant has been reviewed and is being executed appropriately, that what's being seized is only what's outlined on the search warrant, that the agents aren't going into areas where they're not entitled to go under the letter of the agreement. And I think having counsel, as Michael said earlier, it sort of helps to have counsel as that buffer, but also to sort of cut through and make sure that you're doing things appropriately, because you don't have an obligation to answer questions, but you're not going to be able to simply tell the agents, we're sorry, we're not letting you in here, your search warrant doesn't apply. That's not going to fly, and you're going to make things much more painful for yourself by taking that type of approach. So I think that's the kind of area where having counsel involved at early stages, whether it's in-house counsel or outside counsel, but experienced counsel who understands how these things work and what you can and cannot do and say, is very helpful. So I want to talk a little bit about responding to subpoenas and civil investigative demands. There's a lot of things that ought to be kept in mind, as and when you receive a subpoena or a civil investigative demand, or really any process from the government. The first thing is, and this sort of should go without saying, but I'll say it anyway, is these are always serious matters. Some of them, not some, they vary widely in the level of severity, but they're all serious. And so getting an understanding of what's taking place, what the risks might be, as much as you can understand about what the government's looking at and how you're being perceived by the government, is all incredibly helpful. Unfortunately, the government does not have an obligation when serving a process to provide you with a detailed overview of what they're looking to accomplish, what they're investigating, etc. They just don't have that obligation, and particularly if their investigation is being conducted in connection with a False Claims Act case that was filed under seal by a whistleblower, the government, in fact, is obligated to investigate that while it's under seal and to maintain the confidentiality of the whistleblower and the filing. So particularly in those circumstances, not only is the government not likely to voluntarily share information with you, but even beyond that, the government is restricted from doing so absent leave of court. So the first thing that I think, and this echoes something Michael said before, is there should be a plan in place for what to do if the government serves process. And that's not just, executing a search warrant. That should also be a subpoena or CID gets served. There should be an understanding of who at the company, who at a given location is going to be the point person who is going to receive that process, interact with any agents that show up, make sure that things immediately get filtered to the responsible actor at the company. That might be general counsel, if the entity has one. It might be another officer in the legal department or employee. It might be the chief compliance officer. It might be a trusted outside attorney. But having those steps in place at the outset so that people have a sort of process and incorporating it into training. You know, one of our colleagues drew a parallel to being prepared and training for a billing and coding audit. And this is sort of, you know, this is a less frequent occurrence than a billing and coding audit might be. But it's certainly something that happens with sufficient frequency in the healthcare space these days that having a real plan in place and knowing how things are going to proceed if and when a subpoena is served helps. And a lot of that will come down to who's the point person, who's ultimately going to be responsible for coordinating the response and handling things. I think that's always helpful. First thing is, you know, once you've got the plan, you figure out where it's going, reading the subpoena, having relevant folks, whether that's counsel's office or senior leadership, read into the situation, understand what's going on, and then reading the subpoena to get as much of a context clue as you can get. Sometimes they'll say directly, we're investigating, you know, this subpoena or civil investigative demand is issued in connection with a False Claims Act investigation that X company is engaging in kickbacks or is engaging in unnecessary medical services. And, you know, that context can help you understand where your company fits in that description, whether it's you that's being investigated, whether it's a third party, and the nature of the allegation. Unfortunately, there isn't always that level of detail, but reading both the introductory language and then also carefully reviewing the requests themselves is often incredibly helpful in getting a better understanding of what the government might be looking at, trying to figure out you know, where the issues might lie and where the focus should be of your efforts. The second thing is retaining counsel. And I understand, as you know, on a webinar that's being conducted by lawyers, that sounds very self-serving, but it's just practical advice. At the end of the day, these are always going to be high magnitude, high risk. Even if you're a third party and you're viewed more as a witness, you want to make sure that the response is tight and crisp and that you're doing things and documenting things appropriately. One of the keys there is not just responding to the subpoena, but one of the things that I think Michael and I would advise clients, and I, you know, certainly have routinely advised over the last decade while responding to prosecutors, is you want to be able to produce documents, gather documents, and take all necessary steps in responding that are done in a way that is documented and traceable, so that if the government later says, well, you're missing a document, or how did you get to think that this is complete, that you can walk through the exact process that you went through. And I will typically play those cards open-handed with the DOJ attorneys who are involved, because I want to avoid any questions of impropriety or insinuation that anything was missing. And the easiest way to do that is to make sure everybody understands exactly what we're looking at, how we're finding things, and how we're running our internal review. So having counsel involved is going to be helpful. If internal counsel is in place, that could be an option as well. But certainly this is something where the involvement of attorneys is not just prudent, but really is necessary. Beyond that, there are a few immediate steps that should be taken. One, a litigation hold notice should go out. Many of you will have seen those before. Generally speaking, they should lay out in brief the nature of the issue, i.e. we received a subpoena from the Department of Justice, or we received a civil investigative mandate, or whatever, a search warrant was executed, whatever it might be. It should provide all the categories of information and documents that are at issue. It should advise all recipients to think and act broadly in terms of preserving documents and outline the time periods, etc. And the goal of this is two things. I mean, one, it's to make sure people know about the investigation and that there's a request for documents so that they can take the appropriate steps to safeguard and protect materials. But the second thing, which is also important, is it protects the company, because in the event that something inadvertently gets destroyed, or there is a problem where documents were deleted prior to the subpoena, for example, and there might be a challenge later, you want to be able to show the government that you took the necessary steps. The other part of that is I always encourage clients to think practically in terms of document preservation. So sending out the hold notice is obviously incredibly helpful and is a really strong starting point. But ultimately, we're dealing with human beings, and things are imprecise when you're just relying on other people. So to the extent you can take affirmative steps, such as making a mirror image, if you identify there's a list of 10 to 20 employees who are at issue in the department that's implicated, or whatever the numbers might be, taking a mirror image of those employees' email folders as of that date and time can be a very, very helpful backstop, so that if anyone does, deliberately in a very inappropriate way or inadvertently delete something, you've got a mirror image as of a snapshot in time and can use that for your searches and then update it as necessary later. Similarly, adjusting technological tools to avoid any inadvertent deletion is helpful. So a lot of companies have auto-delete functions on their servers where materials might get automatically deleted after 60 days or 90 days. So removing or turning off those functions or modifying them, and some, frankly, email servers have a function called legal hold, which helps with preventive steps on this front. All of those tools are incredibly helpful to avoid the deletion or removal of any data or documents inadvertently. So I would strongly encourage everyone to consider what documents and protection they may have in place, but also to make sure that they're identifying and taking steps to turn off tools that would otherwise be deleting things. Beyond that, you need to figure out how you're going to gather documents. And so again, I like to do things in a very firm and formulaic manner so that it's directly traceable and explicable to the government if a challenge is ever lodged. So to me, that means figuring out who the relevant custodians are, sitting down with in-house counsel in the compliance department, figuring out who the relevant individuals with documents are going to be, making sure to pull their email folders, and then running search terms on our end, figuring out how to calculate search terms so that we're not being overbroad, but we're addressing the government's concerns and communicating those search terms to the government. We typically would recommend, and the size and scope may impact this, but we would typically recommend conducting what I call document custodian interviews, which are non-substantive interviews, but we sit down with the folks most likely to have key documents, and we walk through the requests with them and gather electronic documents on site and provide them an FTP link to upload electronic documents. And again, the concept here is to provide as much detail and support and a robust process be put in place to minimize the risk of things inadvertently not getting produced or people not taking this as seriously as they should. Beyond that, I think you want to always proactively communicate with the prosecutors. That's one of the first steps I always take. We want to do an introductory call, let them know that the entity is represented or the individual is represented by counsel, and communication should come through counsel. It can be helpful in terms of getting an extension of time, which the government is typically very much accommodating in terms of providing that type of extension. It can be helpful in limiting the scope of the subpoena or CID. That doesn't always happen, but it can't hurt to ask. And sometimes what we've been able to do is not necessarily get a limit on the scope, but we can get it modified such that the government may agree to focus on certain priority requests immediately and table the others. And then we can revisit the scope down the road while also using our time effectively at the outset to get the government what it's looking for. Or we might put the email searches to the back of the line, produce the other documents first, which can help us better calibrate the email searches and avoid spending a lot of time and money going through documents that ultimately aren't going to be responsive or necessary in the government's eyes. And then the last thing that we would recommend is conducting an internal investigation. And that's always a tricky one. We have lots of clients who will get this type of request and they're very confident in their own operations and not necessarily unfairly so. They've got a strong company and strong corporate culture, and they take compliance very seriously, et cetera. And their perspective is ultimately, why are we going to spend a ton of time and money here on an internal investigation? We didn't do anything wrong. We know we didn't do anything wrong. So let's just move on. We don't want to spend that extra time and money. And I think, from where I'm sitting, that's ill-advised, because ultimately you think you didn't do anything wrong, but you don't know if there was a rogue actor. The company might be great, but one rogue employee could have created a problem. And so I think making sure you conduct an internal investigation, some of that's going to happen naturally in the course of reviewing documents for production to the government, but you don't want to produce documents that have the government digging in and not understand what they might be finding or if there are issues. You want to be able to be proactive with the government such that if issues are identified, you're able to quickly address those and raise that discussion with the government.
And David, if I could jump in and just add a couple of points. On the first bullet point about reading the subpoena, for a civil investigative demand issued pursuant to a False Claims Act investigation, if it is signed by a local U.S. attorney, then that most likely means the government has determined that the gross amount of damages, assuming all the allegations are true, are $10 million or less. If, on the other hand, the civil investigative demand is signed by the director of the civil fraud section of the DOJ in Washington, D.C., that means the government has most likely determined the gross damages are $10 million or more. So there's a clue in the signature line about the potential scope of the damages in a particular investigation. And then I would just reiterate the second to last bullet point about proactively communicating with prosecutors. I used to always, back when I was at the office, try as soon as possible to have an in-person, face-to-face meeting. Obviously, this was pre-pandemic, but it was a good way to start building rapport and opening lines of communication. I can't overstate how important that relationship is between defense counsel and the prosecution team to resolving False Claims Act cases in particular. And a lot of that has to do with there's a lot of play in the joints when it comes to False Claims Act cases because the government declines to intervene in most key TAMs, roughly 75%. So there's room for persuasion and back and forth. And so I do recommend as soon as possible having that face-to-face meeting.
Perfect. Thank you. So let's talk a little bit about communications with the government. And I alluded to some of this while we were on the prior slide, but I think there's a lot of purposes here. And some of it is as simple as figuring out ways, to adjust timing, obtain extensions, reach agreement on production on a rolling basis, and things of that nature, which can ultimately be very helpful in ensuring that you minimize disruption while still responding fully. Some of it's about truly staggering and staging the discovery so that you're able to modify it. The government may narrow certain requests. You might be able to point out to the government, we don't really have X, or we could pull this type of document, but in order to do that, we would manually need to review thousands of patient charts. And the answer might be not, okay, then don't do it. It might be, let's take a 6-month sample initially, or let's figure out other ways to narrow it. So having a productive dialogue there is helpful. The third bullet point here is sub-bullet, glean more details about the investigation, I think is the trickiest one, because again, particularly where there's a key TAM, that the government is investigating it is under seal, the government cannot reveal that key TAM, the existence of it, and cannot provide some of the substantive details of their investigation. And that always makes things a little bit stickier because it's harder to have then a productive dialogue with the government when ultimately you don't yet have those details. And so I always look at it and, I think, I have clients who tell me all the time, we want you to ask whether or not there's a key TAM. And so I'll ask the question of the prosecutor and sort of say sheepishly, look, I know you can answer this, but I need to ask because my client wants me to ask, and so I do. But there are ways of saying, can you tell me anything more about the focus? Can you tell me how, the client is being viewed here? In the criminal world, there's sort of terms of art in terms of witness, which is sort of self-explanatory, target, which is sort of self-explanatory, and then subject, which is a giant, vast expanse of gray in between those poles of witness and target. And so figuring out where there might be room to maneuver, so to speak, or where there might be gray and we could get more definition added is always helpful. And sometimes the government will give context clues. Sometimes they'll identify specific requests that are a priority for them. And in doing so, that in and of itself will reflect a little bit more about what their focus is and what they're looking at. So asking those questions is helpful. The declare intention to cooperate is not a bullet that I include lightly or that I take lightly. I'm a big believer, as I said earlier, in doing things open-handed. I think one of the most important things is not just developing a rapport with the DOJ attorney so that they think you're a pleasant and likable person. It's really about building credibility. I want the DOJ attorneys to understand I've handled these things on many occasions previously. I know what I'm doing. I'm going to have a robust process in place. And when I say my client's going to cooperate, here's what it's going to mean. We've got a legal holder. We've put these electronic system holds in place. We're conducting custodian interviews. We're going to run our email search terms and custodian list by you before we simply move forward. And we'll take your feedback. And I don't automatically agree if the government says we think you need to broaden up the terms. There are times when I think the DOJ proposes terms that are simply broader than what I view as appropriate and would create unnecessary expense. And in those instances, I'll absolutely push back. But having the dialogue and being direct in terms of we're here, reputable counsel's involved, and we're going to work this through, I think that's important. And then the last bullet, I would actually tweak as I'm thinking about it the way we wrote it. I think starting to preview lines of defense is helpful, but I look at it as we always want to drive things towards a productive dialogue with the government one way or the other. So ideally, that's starting to set up the lines of defense and ultimately leading to presentations or dialogues on the substance, as to why the government is barking up the wrong tree and there's nothing to see here. Sometimes we go through the process, we're doing an investigation, and we discover that there is a problem and that the client may have dropped the ball somewhere along the line. But fortunately, that's few and far between that happens. But in that event, I'm going to go in, or at least if the client is agreeable to the approach, I'm going to go in and say, look, government, here are the 10 or 20 worst documents you're going to see. Here's where the skeletons are. We don't want to hide the ball. We've gone through this. We recognize inadvertently we've stepped in the mud a little bit, and we'd like to flag it for you early on in your investigation, and we'd like to reach a settlement, because I think that's going to help. The government is going to see what's in the documents. You're not going to gain anything by making them jump through a million extra hoops, and you're going to end up delaying things a lot while not getting the benefit of being proactive and candid, and particularly in the healthcare context where you might have to deal with the risk of a corporate integrity agreement from the OIG, et cetera. Having that kind of frank dialogue can be incredibly helpful in sending a message that we're going to approach things appropriately, we're going to be candid, and we're going to try and be direct with you. And I do try and do that. So with that, I'll turn it back to Michael.
Thanks, David. Let's talk about internal investigations. So first, reactive versus proactive. Obviously, proactive are generally preferable. Reactive, it's coming after an indication of government scrutiny, either the execution of a search warrant or service of a subpoena, or maybe negative media attention or the service of a civil complaint. Proactive is information obtained by a compliance officer or information uncovered during an audit or a call from a whistleblower or a call to the hotline. And what is the goal of an internal investigation? It's to figure out the who, what, why, when, and where, right? So you want to better understand the facts, what happened, determine root causes, the why and the how, and determine who is responsible and who knew what when, which is particularly salient for questions about scienter and intent and knowledge. And a good thorough investigation will aid in determining appropriate corrective and proactive measures and best position the company to how to approach, whether to approach and how to approach the government. Do you self-disclose? Do you cooperate? Or is that not necessary because the issue is not significant? And ultimately, a counsel-led internal investigation, an important part of it is it will protect the company's confidentiality through the use of the attorney work product and attorney-client communication privileges. So talking about the investigation itself, first, David, what are the factors that in-house counsel should consider when deciding whether to conduct an investigation internally versus retaining outside counsel?
Sure. I think there's a lot of things to consider on that front. Some of it's going to be what the scope and nature of the investigation entails. Oftentimes, in-house counsel may not have the depth or resources in terms of personnel to conduct a review that might entail thousands of emails and things of that nature. So first of all, figuring out size, staffing, and things of that nature is helpful. Second, figuring out who the ultimate stakeholders are. Sometimes the decision that's being challenged or the issue might have come out of or been supported by counsel's office or compliance, in which case they certainly shouldn't be controlling or monitoring the internal investigation. That's an unfortunate circumstance when it arises, but it does arise from time to time, and obviously then it's not going to be a best practice for them to be monitoring the investigation that could, involve them in light of things that they ultimately were responsible for. So figuring out those things is initially, I think, very helpful. Figuring out the nature of the issues and the relevant expertise is going to be helpful. And then also, if you think that ultimately there's a real possibility of external actions being taken, a refund, a self-disclosure, then it can be helpful to make sure you're doing things as formulaically as possible and have someone, involved that can act as an advocate on your behalf to the government. And then the last thing is, while actions taken by the general counsel are privileged, there's no carve-out to attorney-client privilege based on general counsel. The privilege is not as absolute in the context of in-house attorneys because they serve a business function in addition to a purely legal role. And so I've certainly seen matters come up where the nature of the privilege and the validity of privilege has been challenged for purely internal conduct. And so that's one other benefit that could arise with involving outside counsel.
Thanks, David. In terms of the nuts and bolts of the outside counsel investigation team, it will likely consist of at least 2 lawyers, maybe more. It may include auditors, paralegals as well. And at a minimum, they will collect and review documents and communications, review key corporate policies, and if necessary, relevant regulatory authority, interview key employees, and conduct any necessary financial and data analyses. In terms of common pitfalls with respect to an internal investigation, a common pitfall is not appropriately cabining an investigation, trying to look under every rock. And if you have allegation, let's say you have a hotline complaint about specific conduct at a specific office, you want to have an appropriate investigation that's informed by that conduct and not turn it into a general compliance audit of the entire organization. Related to that is getting in the weeds and seeking too much information, collecting too many documents, and to the extent where the team is overwhelmed with hundreds of gigabytes of data and the vast majority of which is not relevant. That obviously can be expensive, time-consuming, and not productive. And finally, a lack of understanding of industry business practices and relevant regulatory guidance for that industry. That's not something that should come up at the end after you've figured out the who, what, why, when, and how. That information needs to be front and center at all phases of an investigation so you know where the potential violations are. So those are the pitfalls I came up with. David, do you have any additional ones?
No, I think that sounds like an accurate summary of the potential pitfalls. Excellent.
Well, let me talk about considerations from the government's perspective, and particularly I could speak to a line prosecutor's perspective. The first question I think every prosecutor is going to ask, was the misconduct illegal and egregiously so? Prosecutors like to think of themselves as wearing the white hat and going after bad actors and bad conduct. They're not interested in being the paperwork police or going after technical violations. So I think, if you're prosecuting fraud cases, you want to see some indications of deception and fraudulent intent. Next was the company acting in good faith. Were these honest mistakes or more of the reckless or deliberate ignorance variety, or, wanton and willful or malicious conduct? And obviously important is, were there significant sums of money associated with the error? If there's bad conduct and it was intentional, but there's no damages, either financial and putting aside patient harm, assuming there's no patient harm, prosecutor's not going to view that as a good expenditure of their time and investigative resources, because there's going to be a low return on investment. More broadly, prosecutors will look at, does this company have a good track record, or are they a repeat offender? As part of an investigation, the prosecutors will look at the compliance program, and they'll try and determine whether they have a robust, functional compliance program, or is it a paper program? Related to that, prosecutors are going to ask how likely is a potential defendant to reoffend. Did the company's compliance program uncover the issue? And did the company appropriately investigate, take remedial measures, and self-report the misconduct? And finally, did the company cooperate with the investigation team? Those are sort of all important factors that prosecutors will consider when evaluating whether to intervene or file a complaint or file charges, or whether to settle or whether to drop it entirely. And if settlement is the right course, the answers to these questions will affect what is an appropriate settlement amount. So with that, I think we will open up the floor for any questions or comments.
And I'm not seeing any further questions. We had answered one that came up earlier. I think one of the other ones is if a copy of the deck could be obtained, and that certainly I'm not sure who will have the final one, but you can email myself and I can make that available. And our contact information is on here. But I want to thank everyone for attending very much. We appreciate your time and interest, and please don't hesitate to follow up with either Michael or myself directly if you have any questions after the webinar, or if there's anything more specific that we could help answer for you. But thank you very much for attending.
Thank you.